Ending Homelessness Project at Tzedek Legal Services. We have Romy Ganschow, who's a staff attorney at the Legal Aid Foundation of Los Angeles here in the Santa Monica office. And we also have Denise McGranahan, who's another attorney at the Legal Aid Foundation of Los Angeles office here in Santa Monica. We have Etta Sue, who is the Chief Deputy City Attorney in the Public Rights Division for the City of Santa Monica. And we have Naomi Sultan, who's a Supervising Attorney at Mental Health Advocacy.
Excuse me, Mike, we're getting a request from Jen to start over due to a streaming issue.
Okay.
And also it's hard to see your mouth, so if you could lift the camera up a little bit.
Alter your screen angle.
Let's see what we can do here.
People without chins should not speak.
That better or worse?
Oh, that's better. We can see like your whole face now.
Okay. And when am I supposed to start again? Okay. Good morning, Santa Monica. I'm Michael Soloff, co-chair of Santa Monicans for Renters' Rights. I want to welcome you to our Renters' Rights training today, how to avoid eviction as after COVID-19 comes to an end. It's hard to believe, but it was a year ago when we held a SMRR webinar designed to advise renters as the COVID-19 crisis was beginning to unfold, how to protect themselves against potential eviction using the tools that were put in place by the City of Santa Monica, by the County of Los Angeles, and by the state. It's now that we've gotten through hopefully the worst of the COVID crisis, and many of us are getting vaccinated, and life may, we hope, God willing, return to normal soon. We thought it was time to speak again about how we make sure that as COVID-19 crisis hopefully comes to an end, that renters are protected and do not lose their homes to eviction. There are a variety of state programs and laws in place, as well as other laws. And we wanted to make sure that you are aware of those, aware of what types of steps you ought to take to protect yourself, and where you can go to get help. To aid us today in putting that information out to the Santa Monica renters community, we've assembled a great panel of experts who've been kind enough to donate their time to this presentation. We're going to hear today from Hana Kommel, who is a staff attorney at the Preventing and Ending Homelessness Project of Tzedek Legal Services. We're going to hear from Romy Ganschow and Denise McGranahan, who are staff attorneys at the Legal Aid Foundation of Los Angeles office here in Santa Monica. We're going to hear from Etta Sue, who is the Chief Deputy City Attorney in the Public Rights Division of the City of Santa Monica. And we're going to hear from Naomi Sultan, Supervising Attorney for Mental Health Advocacy Services. So please sit back, listen to what folks have to say today. This will be recorded and available for people to look at on YouTube as we go forward. You should be aware this is being recorded. If you do have any questions during the webinar that you would like the panel to answer, if we have the time to do it, please email those to info, that's INFO, at SMRR, that's SMRR.org. So email any questions you have to info@smrr.org. And before we turn to our panel, I'd like to turn it over to one of the founders of SMRR and my co-chair, Denny Zane.
Hey, Mike, is this where I get to be the pretty face?
Yes.
Thank you so much, everybody, for joining us. I'd really like to thank all of our panelists for the expertise they're about to provide you. You all know SMRR. We've been around about 43 years here in Santa Monica. 2 years ago this month, just 2 weeks ago, we had our weeks ago, we had our 42nd birthday, the birthday of rent control, where we in Santa Monica voted to adopt the nation's strongest rent control law and really, I think, set a standard for renters' rights in California, perhaps in the nation. A lot has happened since those 42 years, not to mention this last year, the lost year. You can see me, I'm here in the Bermuda Triangle right now. And time has stood still for me for about a year, I think. And that's not to make light of the tragedy many others have experienced, perhaps some of you have experienced. We are here to help. And if you need help, SMRR and info@smrr.org is where you can reach out to get help. We're going to give you lots of really good information. And I'm going to go back here and hunker down on the beach. Well, no, I'll be listening and available if I'm needed. Thank you, Mike.
Thanks, Denny. And so with that, we're going to begin with Hana Kommel, and she's going to be talking about state law and state rental assistance program. So Hana, can you take it away? Remind everybody who you are and give them the good information.
Sure thing. Thank you, Mike. So my name is Hana. I work with Tzedek Legal Services, and I'm on the Preventing and Ending Homelessness project as a staff attorney. And just as an aside, Tzedek Legal Services provides free legal services to tenants in LA City, Santa Monica, and several other cities throughout the county. And we provide services regardless of immigration status. Next slide, please. And I'm so glad to have the opportunity to speak with everyone today. I know that these laws are, there's just been a lot of them, and so it's been pretty confusing. And we just want to break it down and talk about everything step by step. So what I'm going to focus on today is the state rental assistance program. I know that that's probably at the top of many people's minds. So we'll go through who's eligible for the program, how it works, and how to apply. We're also going to hear from others on the panel about COVID-19 eviction protections. There's a variety of different protections which they'll speak about, and just really thinking about how we can make sure that tenants stay housed during this difficult time. We're also going to hear specifically about the Santa Monica COVID-19 protections, which are specific to the city, and then a little bit about how consumer debt related to the pandemic works. Next slide, please. So I imagine this is what many of you came to learn about. You've probably heard that there is a state rental assistance program right now, and I think it's about $2.6 billion that have been allocated towards tenants that have struggled during the pandemic. And the good news is that these rental assistance funds, they're now finally available and you can apply. And what these funds are designed to pay for is three things. The first thing is unpaid rent from April 1st, 2020 to March 31st, 2021. And so that's what these funds are prioritized for all of that back rent. Now, the funds can also be used to make partial rent payments for the months of April, May, and June of 2021. And when I say partial payments, specifically, those would be payments of up to 25% of the monthly rent. And we'll talk about that a little bit later, but the reason for those partial payments is that that will provide certain eviction protections. And then the other thing that the funds can pay for is utilities. So those are the three things. And again, they're really prioritized for that unpaid rent. So that's probably where it's going to be, where the funds are going to be used first. Next slide, please. So let's talk a little bit about who's eligible for the funds. First of all, it's residential tenants specifically. It's going to be limited to people with household income of no more than 80% of area median income, and we'll explain exactly how to calculate that. And I should note here that people with income no more than 50% of area median income are prioritized for getting this money. But the cutoff is at the 80%. The funds are require that the person has qualified for unemployment benefits, at least one person in the household has qualified for unemployment benefits or has experienced a financial hardship related to COVID-19. And that at least one person in the household can demonstrate a risk of homelessness or housing insecurity. And that could be something like, an invoice or a notice for unpaid rent or utilities. And then I just want to point out here that undocumented tenants are eligible. A lot of people are calling us, wondering whether they can apply if they don't have status. And the answer is yes. You don't need to have any particular immigration status or paperwork to be eligible to receive these funds. Next slide, please. So I mentioned that the household income must be no more than 80% AMI. And what that means is let's say for a family of 4, you'd have to make no more than $90,100 in gross income per year. And if it was, let's say, a family of 1, that would be capped at $63,100. And as I mentioned, if you make less than this, if you're at or below 50%, then the priority goes to households like that. Next slide, please. So here's how the program works. I just kind of went over the eligibility requirements. I'm going to stress here that the program, the rental assistance program, is going to select some eligible tenants. So just because you're eligible doesn't mean you'll necessarily be selected. As I mentioned, there is a set amount of money, and it's possible that more people will apply than there is money. And that's why it really makes sense to apply as soon as possible. Just get your application in. So the program is going to select some of those people who are eligible. And if the landlord agrees to participate, then here's what's going to happen. So with regard to that April 1st to March 31st period, the program will pay 80% of the household's unpaid rent from April 1st, 2020 to March 31st, 2021. And then in exchange for getting that 80%, the landlord is going to agree to forgive the remaining 20%. So let's say the tenant owed $10,000 from April 2020 to March 2021. The landlord would get $8,000, and then they would forgive the remaining $2,000. Now, if the landlord does not agree to participate and accept this money from the rental assistance program, the program may pay the tenant directly up to 25% of the unpaid rent from that period. So, and then what would happen is the tenant would still owe the remaining amount of money, but they could not be evicted for not paying that remainder, and that's because of certain state law protections. So going back to our example with the $10,000, if the landlord said, I'm not going to accept the money, the program could pay up to $2,500 for the tenant, but then they would still owe the remaining $7,500. Now, I want to point out here that rental assistance, that this rental assistance program is counts as source of income under fair housing law. And what that means is we as advocates, we believe that the landlord needs to provide, needs to accept the money, but we can't say for sure whether landlords will or won't. We would think that this would be discrimination if the landlord is refusing to accept the rental assistance money. But again, we're just explaining the process of what happens if they do or don't, because at the end of the day, we don't know we know that some landlords are going to refuse the money. And so we're just explaining how it works. Courts haven't really looked at this issue yet, so we don't know how it will turn out. Next slide, please. So here is how you apply. So the first thing you're going to do is you're going to go to www.housingiskey.com. If you go to that website, it'll take you to this place, this longer link, housing.ca.gov. And then you click for rental assistance, and then you click I'm a renter. And so then it's going to take you to the application. And what'll happen next is you're going to enter your address. And that's the reason you enter your address is they want to make sure you're applying through the proper place. Now, if you're in Santa Monica, the proper place is the state website, so you'll be fine. But so you'll enter your address and then click a button to start applying, and then you'll answer a few just basic eligibility questions similar to what I just described. You know, it'll ask you about your income. It'll ask whether there's a risk of homelessness or housing instability. And then you'll be directed to this other website, which is neighborlysoftware.com. And that's where the application lives. And then on that application website, you'll have to enter certain information about your housing and financial situation. You'll have to upload some documents, and then you'll submit it. Now, if you have questions, you can contact this number that's also listed on the state's website. It's 833-430-2122. Now, if you are having problems with the application and perhaps you try to call this number and that's not helpful, please reach out to SMRR, because we just want to know about experiences that people are having and potentially advocate for for more help and just trying to make sure that tenants are really able to apply for the assistance that they need. Next slide, please. Okay, and then at this point, I will turn it over.
So Hannah, just before you turn it over, I just wanted to ask you a couple of questions.
Sure.
So am I right? I know we're gonna hear more about the law, but at least the idea behind this state rental assistance program is that if you qualify and if they have enough money to do it, they will give you enough money either in cooperation with the landlord or on your own, so that you can pay the landlord enough that you will not be able to be evicted for not having paid your rent up through the 31st of March. Is that right?
Yes, that's exactly the idea.
And so would you say that, you'd encourage people that it's pretty important to at least try to apply for this if you think you're at all potentially eligible?
Absolutely. People should apply right now.
Okay. And I just want to, yeah. And so I think we want to make sure everybody hears that message. If you think you might possibly apply, you should definitely do so. You should definitely do so right away. And we're very serious about wanting to hear if there isn't adequate support. The state website says that phone number that they showed you would allow somebody to actually sit on the phone and help walk you through this application process. But sometimes we're hearing that this may not be working. And it's really important that we know. And the two ways you can contact us at SMRR again are to send an email to info@smrr.org, or you can call our tenant hotline, which we're going to talk a little bit more about at the end of the presentation. But that phone number is 310-394-0848. And we have been previously talking with Senator Ben Allen, with Representative Richard Bloom. I know they're concerned and want to keep their constituents in Santa Monica and throughout the state of California housed. And so it's really important, whether you have a good experience or a bad experience, if you would let us know so that we can continue to be effective in that advocacy. Okay, great. Well, thank you. And now we'll turn it over to Romy Ganschow and Denise McGranahan of LAFLA.
Thanks, Mike and Hannah. My name's Romy Ganschow. I'm an attorney at the Legal Aid Foundation of Los Angeles office in Santa Monica. My colleague, as Mike mentioned, Denise McGranahan, is another attorney in our office, and we have even further attorneys who work specifically on housing issues for tenants in Santa Monica, and as well as some other issues at the Legal Aid Foundation of Los Angeles. We work on sort of all form of civil legal issues that you may have. So we look forward to being able to work with you and help you with any issues, particularly those related to staying housed. So I'm going to talk a little bit about the COVID-19 eviction protections that Hana was sort of touching on. These are the laws that are in place right now to specifically ensure that people don't lose their homes during the pandemic, and to some extent a little bit after the pandemic as well. So there are some state level protections we'll talk about, some federal rules that are in place. There are also some local laws that Etta from the city attorney's office is going to talk mostly about. Before we talk about these COVID specific protections, though, I just want to make very clear that whether we're in a pandemic or not, the landlord always is required to go through the unlawful detainer process and get a court order before they could evict you. The landlord cannot change the locks, get the sheriff out there to change the locks, or force you to move out without going through the unlawful detainer process. So that's true whether we're in a pandemic or not. If you get any sort of notice or anything like that from your landlord that they might be contemplating an unlawful detainer, it's really important to try to seek legal help as soon as you can. The sooner you contact a lawyer at LAFLAB, at Tzedek, or otherwise, the better, the more we can do to help you to prevent the eviction. So to touch on some of the statewide eviction protections that are in place right now because of or as a result of the pandemic, the main law that we talk about is called SB 91. There was an earlier version that was called AB 3088, but the point is it's the COVID Tenant Relief Act. So this law does a few things. One of the things that it does is it extends what we call just cause protections to all tenants throughout the state of California during the pandemic. So that's going to be through June 30th of this year. So this means that the landlord needs to have a good reason to evict you. They can't just say your lease is expired or I just don't like you anymore. That's not a valid reason to evict a tenant during the pandemic. Now in Santa Monica, most tenants already have just cause protections through the variety of laws that we have here in Santa Monica that protect you if you're in rent control or in most housing, even if you're not. But these protections have been extended to all tenants statewide through June 30th as a result of the pandemic, or a version of these protections. The other thing that SB 91 does is it also protects qualifying tenants from being evicted for not being able to pay the rent during COVID. And this is a permanent protection. So if you are not able to pay the rent because of COVID and you follow the steps that are required under the law, you can never be evicted for not paying this rent. It's not a matter of just kicking the can down the road and giving you more time to pay it, but you can never be evicted as long as you follow the steps and you qualify. And we'll talk about what those steps are. So specifically for non-payment evictions, the law also includes some requirements that landlords have to follow for if the tenant has not paid rent during the period of March 2020 through June 2021. One of the big things is the landlord now has to give landlords have to give tenants a 15-day notice to pay rent or quit. So you may be familiar that before the pandemic, and when the pandemic's over, very likely the landlord has to give just a 3-day notice to pay rent or quit. But when we're talking about rent that's due from March 2020 through June 2021, they have to give you a 15 days notice to pay rent or quit. The notice also has to include certain language to advise tenants of their rights under the state law, as well as the forms that are necessary for the tenants to take advantage of the state law protections. So specifically, if a tenant owes rent from March 2020 through August 2020, then the tenant can't pay that rent because they've experienced some COVID-related financial problem, then the tenant just has to give the landlord a signed declaration of COVID-related financial distress. They have to give that within 15 days of getting a 15-day notice to pay or quit. And if you do that, then you can never be evicted for not paying rent during that period of time. You may still owe that rent, and that's part of what we'll talk about at the end a little bit, but you can never be evicted for not paying this rent as long as you provide a declaration of COVID-related financial distress within 15 days of getting a notice to pay. So it's a little chart that shows, represents a little bit of what this looks like. So again, if you get a 15-day notice to pay rent or quit, and it asks for rent from March 2020 through August 2020, you could either pay all of that if you happen to have the money, good for you. And then you would obviously get to keep your apartment, and everything would be taken care of. If you can't pay it, and many, many tenants right now can't pay their rent, and the reason you can't pay it is because you've experienced some COVID-related financial impact, then you can just give the landlord the declaration of COVID-related financial distress. And again, under both scenarios, you still get to stay in your apartment. You don't have to move. You don't have to risk homelessness. If you decide, I don't want to have this debt, I'm just going to move out, you would obviously forfeit your rights to the apartment and have to, face finding a new place to live. And if you do nothing, if you don't respond to the 15-day notice to pay rent or quit at all within the 15 days provided, then your landlord could proceed to file an eviction case against you and potentially obtain a judgment against you, both for the money that you owe and a judgment of possession for the apartment, and they could get the apartment back. So it's really important, if you do get a 15-day notice, to contact and try to seek legal assistance as soon as possible, and keep in mind that you do have to respond to that within 15 days. Now, if you owe rent between the period of September 2020 through June 2021, there's a similar process to follow, but there's another element that needs to be followed. So again, if you can't pay the rent during this period of time, then you can give your landlord the declaration of COVID-related financial distress. You also need to pay at least 25% of each month between September 2020 and June 2021. You need to make that payment by the end of June 2021. As long as you do that, then again, your landlord cannot evict you for not paying the remaining 75% of the rent. So again, this time it's a little bit of a three-step process. If you get a 15-day notice that asks for rent, any rent during the period of September 2020 through June 2021, you can pay all the rent, that's great. If you can't pay the rent, you can give your landlord a declaration of COVID-related financial distress and make sure that you pay at least 25% of each month's rent by the end of June 2021. And then again, you get to keep the apartment and you cannot be evicted. Again, if you do nothing and don't respond to the 15-day notice at all, your landlord could file an eviction case against you and could both get a judgment for the money that you owe in eviction court and could get a judgment of possession for the apartment. So I keep using this term, declaration of COVID-related financial distress. It's kind of a mouthful. And what this is a form that a tenant who has experienced some sort of financial impact due to COVID simply has to sign and return to their landlord if they get a notice to pay or quit. I've included a copy here of sort of a sample form that you might get. Now, again, your landlord is required to give you an unsigned version of this form if they give you a 15-day notice so that you can just sign it and give it back to them. When you sign this form, you're signing it under penalty of perjury. So it's important to make sure that you're being truthful. What the form does is it lists out 6 different ways that you might have experienced COVID-related financial distress. We think about the classic example as you lost your job or lost hours, and that's obviously one of those examples. But there are other ways you might have experienced COVID-related financial distress, like you've had to pay for more out-of-pocket expenses because you're, you can't take public transportation anymore, or you have increased childcare expenses because your children aren't in school anymore. There's even a catch-all category here. So we don't want to think too narrowly about this. We want to think about all the ways in which COVID might have financially impacted you. And if you've experienced at least one of these forms of COVID-related financial distress, then you are eligible to sign this form and return it to your landlord. And you don't have to identify which of the forms of distress you experienced. We do recommend, though, that when you return a form like this to your landlord, that you write the time period that it relates to on the form. So if you got a 15-day notice for the months of September and October, it's a good idea to write on this form that you're returning this form to apply to those months. You don't have to wait to get a 15-day notice in order to give your landlord the declaration of COVID-related financial distress. The key thing is that if you do get a notice to pay or quit from your landlord, that really starts the 15-day clock for you to get the declaration back to them. And so we recommend, even if you might have given one to your landlord in advance, a signed declaration, you should also give it to them if they give you a new 15-day notice, just to cover all of your bases. But the point is, it's not too involved of a process. You really just have to sign the form and get it back to your landlord within 15 days of them giving you a notice to pay or quit. The other important thing to keep in mind, and this is a good rule of thumb, again, whether we're in the pandemic or not, when you're making your 25% partial payments that you have to make between September 2020 and June 2021, again, it's okay if you don't pay that until the end of June, as long as it's all paid by June 30th, 2021. But if you're making payments along the way, it's a really good idea to write on the payment, the check or the money order, exactly what the payment is for. So if you're paying 25% of 3 months rent, and so you're basically paying 75% of 1 month's rent, you want to write on the check those 3 months that you're paying your 25% for. So it's very clear how the landlord's supposed to apply the payments. There are some rules to prevent landlords from kind of engaging in funny business over this, but it's still important to kind of protect yourself, cover your bases, and try to be as clear about that as possible on your payments. If you get a 15-day notice to pay or quit, and for some reason you are unable to return the signed declaration to the landlord within 15 days, there's still a possibility that you might have another chance to do this. So again, if you don't return a signed declaration to your landlord within 15 days, then your landlord can go ahead and file an eviction case against you. Once you get the unlawful detainer summons and complaint, you have 5 days to file a response in court. And that's the same again if we're in the pandemic or not. The unusual thing right now is that that response can include a request to the judge that you want to have one more chance to turn in your declaration of COVID-related financial distress. You want to have a chance to turn it in a little late. And you have to explain, and you have to later need to establish for the judge that you had a good reason for why you were not able to get it to the landlord within the 15 days in the first place. And that's ultimately going to be up to the judge to decide whether or not you had a good enough reason for being late with the declaration. So you don't want to leave it up to the judge. You want to do everything you can to return the declaration on time. But if for some reason something happens and you're not able to, there might be this last ditch opportunity. I also want to highlight here, reasonable accommodations are something we always think about when we're working in our space. And so if there's some disability related reason why you're having trouble responding to your landlord or returning the declaration, that's always something we want to keep in mind, and something if when you contact an attorney, you want to also be prepared to discuss that with them. I also want to touch on the state law says that if you owe rent during this COVID period of time, so that's essentially the entire period of time of March 2020 through June 2021, your landlord can't come up with another reason to evict you and still try to get that rent money. We don't want them to say, oh, I'm really evicting her because I don't like her dog, but while I'm at it, I want to get this money she hasn't been paying me because she lost her job. So if your landlord does try to evict you for a reason other than non-payment of rent, and you owe rent money during the COVID period, your landlord cannot try to seek that rent money during that other eviction case. And I will say that we are seeing more of these types of cases of landlords coming up with other reasons to try to evict tenants because they're really limited in their ability to evict tenants for not paying the rent right now. And so this is really something to keep in mind. I'm going to briefly touch on an order that's been issued by the Centers for Disease Control at the federal level, which prevents evictions in certain cases. It's a little bit less protective in some ways than our state laws. So for most tenants who owe rent during the COVID period of March 2020 through June 2021, we're not really relying on this because our state laws are stronger. But for tenants who maybe owe rent from before the COVID period, or may have an ability to pay the rent that's not related to COVID, or tenants who may have had an eviction that was entered before COVID, but nothing has happened because of the sort of the slowdowns related to COVID, this CDC order can be a useful protection. All that the CDC order will do, though, is it will just delay your lockout. It doesn't actually prevent the landlord from evicting you, whereas our state laws can actually permanently prevent the landlord from evicting you for COVID-related rental debt. So again, this is not going to be used in a lot of situations where you just simply can't pay the rent because of COVID, but it is kind of another protection that we want to have in our toolkit in case we need it. It can also be used, as I said, for tenants who maybe are being evicted for something that was not their fault. But if they were to be evicted, they'd have a really hard time finding a place because of COVID. And the last thing I wanted to touch on is a sort of a related state law that says that a landlord cannot increase the rent by more than 10% when we're in a state of emergency. So in California, we are been in a state of emergency related to COVID for over a year now. We were also in a state of emergency just before that because of wildfires, and there was recently a state of emergency declared the other day for certain counties because of drought conditions. But basically what this law says is that during the state of an emergency, a landlord cannot increase the rent to a current or future tenant by more than 10%. So that means even if the tenant before you moved out, the landlord's not supposed to charge you more than 10% of what they charged the previous tenant. But also if you're a tenant who remains in occupancy, the landlord can't increase your rent by more than 10% at any given time during the state of emergency. And for those tenants on here who have the benefit of rent control, this is sort of, you may not ever need to take advantage of this, but many tenants don't have rent control. And so this is another protection. And now I will turn it over to Etta and let Mike have some questions. Sure.
I do. I guess that's who I am.
Of course, not Mike, but everybody, yeah.
So one thing that I wanted to check, so we've described some of the things that people ought to do. Do you have any advice to them in terms of keeping records or proof that they actually did these things?
Right. I mean, so it's a good idea to take photos of your rent payments or your declarations that you might be giving to the landlord. If you're sending your landlord your declaration of COVID-related distress by mail, to the extent you can send it through some sort of certified or registered mail, so you have some confirmation that you sent it, that's a good idea. You can also personally deliver documents to the landlord. And in that situation, I often advise people to take photos with the and video with the landlord's consent that you're doing that. Just sort of cover your base and think about the worst case scenario if you were to go to court and had to prove that you had actually done what you were required to do. Of course, it's always a good idea to pay. You should never pay your rent by cash. If you do, absolutely demand a receipt for doing so, but otherwise make your payments, including partial payments, by check or money order.
Okay, great. And so for everybody watching, be aware at the end, we'll have a slide that will show you how you can contact the organizations and the presenters here. Legal aid is obviously one of the frontline sources for tenant lawyers here in Santa Monica. And there's actually been a recent expansion by the city of its contract with LAFLA to make them even more available to people. So just be aware, we'll be providing that information at the end. This is just also to remind everybody, we are recording this event. And if you have questions that you'd like us to try and answer during the webinar, please send them to info@smrr.org. Okay, and with that, now we can turn it over to Etta.
Thank you. Thank you, Romy, for that presentation. Yes, good morning. My name is Etta Sa, and I'm the Chief Deputy City Attorney from the Public Rights Division of the City Attorney's Office. This morning, I am going to talk about Santa Monica COVID-19 tenant protections. That can be separated into two types of citywide protections during the pandemic. Number one is the city's eviction moratorium that addresses evictions. And number two, the city's tenant harassment protections. These two categories are not necessarily distinct because some evictions can also be tenant harassment. For example, where a landlord brings a baseless pretextual eviction action in bad faith, that could violate both the city's eviction moratorium and our tenant harassment ordinance. So with that background, let's get started. Santa Monica's COVID-19 eviction protections. We're back. Can we go back one page? Thank you. On March 14th, 2020, the city issued an emergency order that included a residential eviction moratorium. Since then, the eviction moratorium has been revised and expanded. There are three main parts to the city's eviction moratorium. Number one, residential eviction protections for non-payment of rent. But as Romy discussed, the statewide protections for non-payment of rent apply to Santa Monica tenants. Santa Monica's eviction moratorium protections covered non-payment of rent for the period up to September 2020. Until then, Santa Monica tenants got dual protections under the city's and the state's eviction moratorium. After September, the statewide protections took over, and we now look to SB 91 for protections for evictions based on non-payment of rent. Number two, the city's eviction moratorium also includes a residential eviction protections for reasons other than non-payment of rent. This part of the city's eviction moratorium is not preempted and remains in effect until June 30th of this year. Next page. Yes, thank you. This covers most types of evictions that are not based on non-payment of rent. So until June 30th, landlords are prohibited from proceeding on the following types of evictions: no fault evictions, including owner occupancy, refusing entry into a unit, having unauthorized occupants or their pets, nuisances, and else evictions. Now, where the health and safety exceptions apply, the tenant's conduct must meet the legal standard. The tenant must substantially endanger or impair the health and safety of a tenant or other persons in the vicinity of the premises, or cause or threaten to cause substantial damage to the premises. This is a very high standard and not easily met. The third part of the city's eviction moratorium is a commercial eviction moratorium, which has been phased out as of March 31st of this year. Next page. So moving on to tenant harassment, let's start by looking first at the enforcement trends that we have seen in the past year, starting in mid-March of 2020. During the past 12 years, since the COVID-19 emergency was declared, the city attorney's office has logged in over 1,470 calls and emails about the eviction moratorium. And we know this is an undercount because this number does not include the calls that went to the other city departments, including the city's EOC, the rent control office, and housing. They all took calls about eviction moratorium, and those numbers are not included here. The city's webpage on the eviction moratorium during this period, we had about 50,000 page views, and 40,000 of which were unique page views. In addition to the calls and emails, the city attorney's office received about 150 actual tenant complaints. Those are reported violations over the past year. And breaking that number down, we got 84 tenant harassment complaints and an additional 63 complaints related to the eviction moratorium. These numbers highlight the point that during the COVID-19 emergency, strong protections and enforcement are needed more than ever. The city has and will continue to take complaints, investigate and enforce local and state laws that protect tenants against harassment and discrimination. The city's tenant harassment ordinance is a key tool for protecting tenants before, during, and after the pandemic. As Denny said, the City Council adopted the tenant harassment ordinance in 1995. Over the years, the law has been revised, and in fact, during the pandemic, while our eviction moratorium is in effect, the maximum penalty for harassment violations is increased from $10,000 to $15,000 per violation. The tenant harassment ordinance lists 12 prohibitions for landlords. They cover most of the harassments we see, including failure to perform needed repairs, abusing landlord's right of access, attempting to get a tenant to vacate using fraud, intimidation, or coercion, refusing to acknowledge receipt of tenant's lawful rent payment, and bringing baseless eviction actions, all done in bad faith. Next page, please. So related to that tenant harassment cases, we saw another trend. In the past year, we received 21 source of income housing discrimination complaints, including Section 8 discrimination and where landlords did not want to participate in the city or county's rental assistance program that was implemented back in July. All but one were resolved without litigation, and the last one remains pending. Today, after my discussion, Naomi Sultan will be discussing fair housing issues related to the pandemic. So this may be a good time for me to remind you about the city's upcoming housing discrimination workshop. It is entitled Fair Housing During COVID-19, and it will be a virtual workshop scheduled for next Thursday. Everyone is invited to attend. The topics will include pandemic-related issues in fair housing, rental assistance programs for tenants and landlords, and source of income discrimination laws. Now, next page, please. Now, what types of harassment are we likely to see continue into the pandemic and beyond? Will there be increased harassment for those tenants who have not paid rent but are protected from evictions under the state's eviction moratorium? The drafters of SB 91 seem to anticipate an increase in this type of harassment. And as Romy discussed, SB 91 contains additional protections to deal with retaliatory or pretextual evictions. Additionally, our tenant harassment ordinance has built-in protections against baseless evictions and attempts brought by landlords who are acting in bad faith. Lockouts. Romy started her presentation with illegal lockouts. Will those be increasing in the coming months? Lockouts are also referred to as self-help evictions, and they are prohibited by law. Our local laws prohibit landlords from disrupting tenants' housing services, interfering with tenants' access to their unit, and removing their property. State law makes it a misdemeanor crime, and anyone who violates is subject to criminal penalties and additional civil liability. Needless to say, we will be looking out for these types of harassment. Recently, the city attorney's office filed a lawsuit against local landlords under both the tenant harassment ordinance and the city's eviction moratorium. The facts of that case highlight many of the trends that we have been seeing both before and during the pandemic. In that case, the new owners had purchased a 30-unit building in 2017. By the time we filed the lawsuit, 23 of the 30 units were vacant. We alleged that the owners were trying to get rid of the 5 of the last remaining tenants using fraud, intimidation, and attempted evictions without justification. The complaint alleged the following facts. The owners informed the remaining rent control tenants that the city had approved the plans for major repairs and the tenants needed to be temporarily relocated. The owners assured the tenants that they could move back into their units once the work was done. And they further indicated that once the repair work starts, the building would be uninhabitable and any refusal to temporarily relocate would constitute a nuisance. When the owners informed the tenants that they needed to relocate, the tenants refused for fear that the owners may not allow them to move back in after the work is completed and due to COVID-19 public health concerns. In November, during the pandemic surge, the owners filed unlawful detainer actions against tenants based on their refusal to temporarily relocate for work that had not been permitted. They brought baseless lawsuits in violation of the city's tenant harassment ordinance and the eviction moratorium. In December, the tenants went to court to fight the evictions with their legal aid attorneys. The owners dropped the eviction actions, only to then serve the tenants with new 3-day notice to quit. At the time the complaint was filed by the city, at the time of the complaint, the city had not approved the proposed construction work, and at least 2 of the units were being listed on Airbnb as vacation rentals. Additionally, the property was being advertised for sale, and the advertisement said, quote, "Only 5 units are currently occupied and seller is in the process of completing the buyouts." The case was filed earlier this year and is now pending in court. Next page. So what should you do if you are being harassed? Contact the city attorney's office, the Public Rights Division. Our phone number is 310-458-8336. Our email is consumer.mailbox@smgov.net. And you can file a complaint on our website by following the instructions. Next page. So looking ahead, there is talk and predictions of a tsunami of evictions that will hit us as the eviction protections expire. And what tools do we have to stave off the wave of evictions? Well, one tool, which is not new, is, of course, the city's tenant harassment ordinance, which we have already discussed. Another tool is the new noticing requirement. As a part of our emergency response, the city, as of December of last year, landlords are now required to report endeavors to evict residential tenants to the city. Endeavors to evict include the 15-day notice to pay or quit served on tenants under California's eviction moratorium, and any complaints filed in court for unlawful detainer. The city is collecting this information not to intervene in an eviction attempt, but to collect information on evictions during the emergency period. Another tool, the Right to Counsel pilot project. It's a 2-year project to provide free legal services to income qualified Santa Monica tenants who are facing eviction attempts by their landlords. The goal is to provide free legal services from beginning to end of an eviction action to those tenant households at or below 80% of the county's AMI, area median income. The program is based on the premise that many households, and certainly tenant households with incomes at or below 80% of AMI, would have a hard time affording an attorney to represent them in court. Studies have shown that the current system is stacked against unrepresented tenants. According to the 2019 Stout report, Los Angeles County's most vulnerable tenants are frequently unrepresented and evicted by landlords who are represented by experienced counsel. We believe that providing tenants with counsel is critical to leveling the playing field and would significantly improve the likelihood that eviction cases are decided fairly and on their merits. According to Stout, 97% of LA County tenants are unrepresented in eviction cases, while landlords are unrepresented in just 12% of their cases. Unrepresented tenants in LA get displaced 99% of the time, but if they get representation, they avoid displacement 95% of the time. Another tool, there are situations where enforcement action is not appropriate or an option. In those cases, we encourage the parties to consider mediation. Last summer, during the pandemic, we partnered with Pepperdine School of Law, Strauss Institute for Dispute Resolution, to make mediation services available to Santa Monica landlords and tenants free of charge. And the last but not the least tool is the state's rental assistance program that Hana spoke of. It is designed to help landlords access much needed financial relief. In California, the governor signed a bill to use $2.6 billion in federal funds to pay landlords up to 80% of the rent owed by qualifying tenants with COVID-19 financial hardships. We are well aware that COVID-19 has impacted landlords and tenants, and smaller landlords in particular may be at risk of losing their homes and investments that they had relied on for retirement and survival. And now landlords can take advantage of the program, survive the hit to their incomes, and keep their tenants. That concludes my portion of the discussion. And unless Mike or Denny have questions, I can turn it over to Naomi Sultan, the supervising attorney for mental health advocacy services.
Just before we go there, I want to thank you and thank the city and remind everybody that it is critical to reach out to lawyers, and the city, both in the past and now expanded, has tried to put in place resources to make that more real in Santa Monica than it is in perhaps some other parts of LA County, and the folks at Legal Aid are an excellent gateway for that. And also, if you are running into these kinds of problems, again, you can let us know at info@smrr.org or on our hotline at 310-394-0848. We're going to talk a little bit more about that, but it's also important, just as we advocate with our state representatives for state level laws and resources, we do the same thing at SMRR with our city staff and with our city council. And so the more we know about what problems renters are facing in the city of Santa Monica, the more effective we can be as advocates for you. Okay, and so with that, thank you. And now we'll turn it over to Naomi Sultan.
Thanks, Mike. So I do work at Mental Health Advocacy Services. My name is Naomi Sultan, and Mental Health Advocacy provides legal assistance to low-income individuals with disabilities. We do a lot of eviction prevention work. In particular, that's my focus. So today, what I'm going to be talking about is rental debt and sort of what happens to the consumer debt that may have been accumulated, or the rental debt that may be turned into consumer debt that was accumulated during the pandemic, and also going to touch a little bit on fair housing issues raised by the pandemic. So what happens to this rental debt that we've been talking about? Hana told us that if tenants submit these COVID-related inability to pay declarations regarding rent that they're unable to pay, basically since March of last year, so March 2020, if they submit those declarations for the rent that was due between March 2020 and August 2020, then that rent is converted to consumer debt, and folks can never be evicted for that back rent. And the same applies to rent that came due between September 2020 and June 2021, as long as tenants pay for that period at least 25% of the rent by the end of June. And again, that's where that rental assistance program can come in. But if folks do this, if they protect themselves, what happens to the debt? So again, you can't be evicted for it, which is great, but the rental debt is still owed. So starting August 1st, landlords can sue tenants for this unpaid debt that may have accumulated, is unpaid rent that may have accumulated during the pandemic. It's important to note that landlords are required to offset any financial assistance they may have received. So if a landlord received 25% of the rent due, they can't sue for that part. They can only sue for the remaining 75%. And I understand that judges are going to be instructed. Most of these cases are going to be heard in small claims court, and the small claims court judges will be instructed to consider whether the landlord refused to accept the 80% if the tenant applied for that. So it's definitely to the advantage of both parties to apply for that rental assistance to cover as much as possible of the debt, which is the 80%. There are also late fees cannot be collected for tenants who submitted the declaration. Also, any rental debt accumulated during COVID cannot be used as a negative factor by tenant screening companies. But it should be known that if, let's say you're sued in small claims court over rental debt, and then there is a judgment against you, the judge finds that you do owe that money, that will go on your credit report. It's also important to note that many, a lot of the tenants that we work with, at least at MHAS, mental health advocacy services, are very low income. They may be living on disability or public benefits, or working low wage jobs. And for folks who receive certain types of benefits or who only have enough money coming in from work to pay their basic necessities, they may be what's called judgment proof, which means that even if a landlord or some other creditor gets a judgment against them that they owe money, there will be no way for that landlord to collect on that judgment if that tenant is very low income or receives certain types of disability benefits. Again, this is exactly the type of thing that you would want to reach out to a legal aid organization for. I know a lot of legal aids, MHAS, Public Counsel, LAFLA, Beit Tzedek, I believe as well, are staffing up programs to help tenants deal with these consumer debt lawsuits that are going to start coming in August. So you definitely want to reach out for assistance on that to make sure that you consider responding to that lawsuit. Next slide, please. There are also some protections for COVID-related rental debt under both state and federal law that I wanted to go over a bit here. Under state law, landlords can't sell the rental debt to third parties until July of this year. This is actually really, really important. All non-payment evictions that were filed between March 4th of 2020, so way back beginning of the pandemic, and June 30th, 2021 are completely masked, which means that they're not going to show up on any type of tenant screening report. So they won't impact a tenant's ability to lease up elsewhere in the future. This is a change from the way things normally are. Normally cases are only masked or sort of hidden from the public if the landlord, for 60 days, they're hidden unless the landlord prevails within the first 60 days of the lawsuit. And in this case, they are hidden permanently for those non-payment evictions that were filed during the pandemic. And small claims actions for COVID-19 debt are also going to be masked. There's a new rule that was just issued by the Consumer Finance Protection Bureau, the CFPB, which is apparently newly empowered under the Biden administration. And this new rule, which is effective May 3rd, 2021, requires debt collectors seeking to evict tenants for non-payment to provide tenants who may have rights under the CDC order with written notice of those rights. Remember, the CDC order, I believe, was something Romy discussed, and it protects tenants. It's a federal rule, a federal order issued by the CDC in order to prevent evictions because they're a threat to public health, right? Because people that are unhoused are more likely to become ill and get COVID. And even though in California, we have a lot of protections that are more robust than the CDC order, it still protects a lot of tenants, for example, those who may have a non-COVID related inability to pay. In any case, debt collectors are required to provide in the first eviction notice to tenants who may have rights under the CDC order, which arguably is most tenants, a written notice of those rights. Debt collectors include attorneys, property managers, and it must be provided in in writing on the same day as the eviction notice. It can't be a text. It has to actually be like a physical writing. And if tenants are not provided this notice, they can sue under the Fair Debt Collection Practices Act, which is a really robust federal law that has significant penalties for violation. Next slide. So I'm also going to talk a little bit about fair housing issues related to the pandemic. I know that Etta mentioned there's a Santa Monica webinar coming up, which will be devoted to fair housing issues, but we're just going to touch on them a little bit. particularly on disability discrimination during the pandemic, source of income discrimination, family status discrimination, and some discrimination that we've seen, unfortunately, an uptick in based on race and national origin. Next slide. So we get a lot of questions at MHAS as to whether COVID-19 is a disability, right? Because COVID-19, it didn't even exist until a little bit more than a year ago. And so there's a lot of questions as to how COVID-19 fits into the fair housing laws that we already have in terms of how folks are protected. So, you know, I think we all know that COVID-19 can impact people in a variety of different ways, right? So some folks may get COVID and they may have, you know, the sniffles, or they may lose their taste and smell, but they're not really, you know, substantially limited in their ability to do major life activities, right? They can still work, they can still walk if they were able to walk before, that type of thing. But some folks that get COVID-19, you know, sometimes folks that have underlying health conditions, sometimes folks that just have this greater exposure, we don't know exactly why yet, may have a more significant kind of response, a more severe form of COVID. And to the extent that somebody has COVID-19 impairments that substantially limit their daily life activities. So somebody that is quite ill, that is in the hospital, that has difficulty, you know, breathing on an ongoing basis, struggles to care for themselves, can't work anymore, difficulty thinking. There's, you know, neurological, psychological effects of COVID that can last for a long time. Those folks would probably qualify for disability protections under both the Fair Housing Act, which is the federal fair housing law, the main one, and California's Fair Employment and Housing Act. You know, the bar under the federal Fair Housing Act protection is substantially limited. You have to be substantially limited in some major life activity. California law, it's just limited. As we know, there may be substantial long-term effects from COVID. So these folks certainly are likely to qualify as disabled under state and federal law. You know, there's a lot of case law relating to communicable diseases like AIDS. And so we know, you know, based on our history in this country of coping with communicable diseases and sort of the discrimination that folks, particularly with AIDS, have faced in the past, that this is this type of impact from an infectious disease that really impacts major life activities qualifies you for reasonable accommodations, and also you know, protects you from affirmative discrimination by housing providers. This may also apply to temporary disability if the COVID-19 is severe enough. And it also applies to somebody who has a history of COVID-19 or is regarded as having COVID-19, even if they don't. There's a lot of you know, misinformation and confusion out there about COVID-19 and what it does and what it doesn't do. And this can lead to prejudicial behavior against people that may be perceived, you know, may actually have COVID-19, may be perceived to have COVID-19. But even if somebody doesn't have COVID-19, but let's say, you know, they work in a hospital and our landlord is refusing to rent to them because they're afraid they'll get it and, you know, maybe transfer it to the other tenants, that's disability discrimination based on perceived disability. Right, so I already went over a little bit more about COVID-19. As I mentioned, you know, if somebody currently has COVID-19, they're likely protected from housing discrimination on that basis. If they have a history of having it, they're perceived to be having it, or even if they're associated with a person that's having it. So, you know, if folks can't be discriminated against, you know, refused rentals, like denied services, all that type of stuff, you know, because they or a family member has COVID, or somebody that may have visited potentially has COVID, or there's perceived to be a risk potentially maybe because that person is a member of a community that has a higher incidence level of severe COVID, absolutely can't be treated differently in housing on that basis. I want to talk a little bit about what housing providers can and cannot do with regard to COVID-19. So housing providers cannot require a tenant to disclose that they have a disability, including COVID-19, or require that they report if they've been exposed or tested. However, landlords and housing providers in general may encourage tenants or applicants to voluntarily self-report that they have COVID or have been exposed. So the distinction there is you can't require, but you can encourage. Landlords may not ask if a tenant has a disability that makes them more vulnerable to severe COVID-19. And they also cannot share a tenant's medical condition or disability with other tenants. So if a tenant does voluntarily disclose to a landlord that they have COVID-19, or they disclose to a landlord that they have an underlying health condition that makes them more vulnerable to COVID-19, say in the context of asking for a reasonable accommodation for a virtual inspection or to postpone an inspection or for more time to move, whatever conditions, medical conditions, disabilities are revealed during the reasonable accommodation request process cannot be revealed by the landlord to other tenants. Something else, in addition to asking tenants to voluntarily self-report COVID-19 exposure, landlords, housing providers may also encourage residents and guests to adopt infection control measures to prevent the spread of COVID-19, like social distancing, masking. They can put up, just like hand sanitizer dispensers. These are all things that landlords may do. And there's also, to the extent that tenants are refusing, say, to mask in common areas, that gives rise to the question of whether, their behavior is potentially directly threatening other tenants. So, because we are dealing with this real emergency, right, as a society, it's important for tenants to try to work with their housing providers to fulfill the infection control measures that are in place. If somebody needs an accommodation for a different type of mask or whatever else, you certainly want to encourage folks to ask for that, to ask for whatever might need their disability related needs, but likely refusing to engage in any types of infection control measures could potentially not be sustainable. Next slide. Excellent. Okay, so this is some examples of disability discrimination that have occurred during the pandemic. Refusing to rent to someone moving from a nursing home due to the assumption that that person contracted the virus. It's likely disability discrimination. Courts have held that rejecting a home health aide because he takes care of a person with HIV/AIDS is discrimination. So again, that applies in this context as well, because we're dealing with an infectious disease. So landlords likely cannot refuse to house or to have an aide come in that may be assisting people with COVID-19, because that's disability discrimination. And we already went over sort of what landlords can ask and not ask. And absolutely, there can be no imposition of limitations in access to housing or housing related services because of COVID-19. So if somebody has COVID-19, but they need something fixed in their apartment, the landlord cannot refuse to come into the apartment and fix what they need to fix. They just have to make sure that all the infection controls that are available are put in place to protect everybody involved. These are some examples of reasonable accommodations that folks have asked for during the pandemic. And again, a reasonable accommodation is a change in a rule or a policy, in this context related to housing, that will enable a person with a disability to use and enjoy the housing of their choice, to benefit from the housing in the same way that people without disabilities can enjoy housing. And denial of reasonable accommodations is disability discrimination. It's actually the most common type of disability discrimination that people report. So absolutely requesting to relocate to a private room if somebody's living in a congregate living facility is an accommodation that folks can ask for during the pandemic. If somebody's living on the street or in a congregate shelter and they want to be moved into a hotel, project room key, whatever else with an individual living space, that's an accommodation they can ask for, particularly if they have underlying health issues that make them more vulnerable to severe COVID-19. Folks may need an extra bedroom on their voucher for a live-in aid if they have ongoing impairments related to COVID-19. Tenants, this is something we do, we did before the pandemic and we're doing even more now, is requesting landlords to rescind eviction notices as an accommodation when the eviction or termination is based on disability-related behavior. It's probably comes as no shock to hear that folks have been stressed out over the last, year and a half. And there's been a lot, and that includes folks with, mental disabilities, right? There's like increased anxiety, depression, all sorts of stuff that people are experiencing at the same time as there's less access to mental health providers because a lot of stuff has gone virtual. So because of this, you can sometimes see an increase in disability-related behaviors, but absolutely folks can get accommodations to make sure that they stay housed, even if they're threatened with loss of housing for some disability-related behavior. Extension of time to move after agreeing to move out by a specific date. Absolutely, the pandemic is going on. I think for a while we thought it would be over, and so folks were agreeing to move out at certain dates, but it seems like we're not quite at the finish line. So folks may need to extend a move out date even further. Extension of trial in an unlawful detainer if somebody is ill, has COVID-19, some other disability related issue. Limiting or prohibiting entry into the unit. We get a lot of calls from tenants whose landlords maybe want to sell the property, and so they want to come in and have people walk through and view the property, or they want to do these like routine inspections that may not need to happen during COVID-19. And absolutely, if a tenant has a health condition that makes them more vulnerable to COVID-19, they can certainly request to do those virtually or put those off. And we get a lot, assistance animals are very popular in general, emotional support animals, service animals, but during the pandemic where people's stress, as I mentioned, is sort of ratcheted up, this is something we're seeing more and more need for, and those are absolutely accommodations, very, very common accommodations, the denial of which is likely disability discrimination. Next page. I want to talk a little bit about source of income discrimination. Santa Monica has had a, let me phrase it this way. Source of income discrimination in California is illegal. And what that means is that, a landlord cannot refuse to accept income, like let's say, refuse to rent to somebody that's on disability benefits, or that receives money from a special needs trust or whatever. They can't require that somebody have, say, a job, right? A paycheck that's paying their rent. Over the last couple of years, this has been expanded both in Santa Monica and at the state level and county and everything else to include Section 8 vouchers and other forms of rental assistance that low-income tenants might need. So it is absolutely illegal right now in Santa Monica and everywhere in California to refuse to accept Section 8 vouchers and other types of rental assistance. And this was an issue that I believe Hana touched on before as to whether landlords' refusal to accept COVID-19 rental assistance, this SB 91 rental assistance, may constitute source of income discrimination. It's definitely a concern. Could you go back to the previous slide quickly? It's definitely a concern. Rental assistance from a government program is a protected source of income under FEHA, which is the Fair Employment and Housing Act. And again, there's not, much litigation on this yet, but as advocates, it is our position that landlords should accept rental assistance as a lawful source of income. Next page, please. Another thing we've seen an uptick in is familial status discrimination during the pandemic. And what that means is discrimination against families that have children, so folks under 18, kids, or a person that's pregnant in the family. That's what family status discrimination means. And I think we all know kids have been at school, not at school. They have been home a lot more during the last year, doing schoolwork from home. I know there's transitioning back to some in-person learning now happening, but in general, folks have been home a lot more, particularly families with children have been home a lot more. Children, because they are children, may tend to make more noise than adults. And so there have been a lot of, issues between tenants of feeling like there's, excuse me, there's a dog situation here. There have been some issues with families with children facing discrimination on that basis. Luckily, there are protections in all of the, particularly in the Santa Monica ordinance and in other ordinances locally for noise that may be related to the pandemic, including kids working from home, teleworking, but stuff like refusing to let children play in common areas, refusing to accept large families, basically treating families with children differently is unlawful. Next page, please. I also want to talk a little bit about race and national origin discrimination. Unfortunately, we've seen a huge uptick in discrimination in the pandemic, particularly directed towards Chinese and Asian Americans. We've been getting reports of this, and I know that this has been a struggle that people have been facing. So absolutely, to the extent that folks are experiencing this type of discrimination, they should report it to the city. They should report it to a local legal aid agency that can assist them. A lot of the discrimination and that takes place takes the form of harassment based on race or national origin. And it can also, oftentimes the harasser, not always, but oftentimes the harasser may be another tenant in the building, right? So it's important to let the housing provider, which is in most cases for tenants, the landlord, know that they are experiencing this harassment by other tenants in the building or the property manager, whoever it is. So because that housing provider is required under fair housing laws to take action to correct the discriminatory and harassing conduct of the other tenant. And there's also a concern that housing providers will make discriminatory decisions as to which tenants they're going to accept the 80% for. And absolutely, so those decisions cannot be based on, race, religion, gender, any of the protected categories under California law. Landlords, if they're going to accept rental assistance, for some tenants, cannot choose not to accept it for tenants that are members of families or based on some race, disability. So it's really important for housing providers to treat tenants equally in terms of accepting this rental assistance. And again, we encourage landlords to accept the rental assistance from their tenants. Okay, so I think that's my portion of the training. I guess we're turning it over to Ed. Or maybe I'm just seeing Ed. I see a lot of Ed.
Hang on one second before we get to Ed.
Okay, right.
So could you go back to the slide that showed how people can contact the website and the phone number for the state rental assistance program? There we go. Great. So we had a request to put that information up again. So why don't we just leave that up for just a second here? And for anybody watching, in addition to having, it be in this presentation, when we put up this presentation on our website and let people know about it, we'll make sure that this contact information is available. Okay. And if you could end screen sharing. And then Naomi, just one question, and I do have to give a shout out to Naomi. While this is her day job at night, she serves as one of the elected rent control board members here in Santa Monica. So both her day job and her night job is about protecting tenants in this city and tenants in general. So I just wanted to understand that, I just want to make sure I understood correctly. So we've talked a lot about that certain types of rent, the state has said you can never be evicted for, and then that's all of the rent up to a certain point in time, and then part of the rent after that. And so your point is that even though you can't be evicted for that, that still is a debt obligation that you owe to your landlord. Is that right?
Yeah, that is correct. And you could be, after starting in August, you could actually be sued on that debt.
Right. And so I wanted to ask you about that. So I also thought I heard you understand that, just like we've talked about it, if people get, an eviction action, they should, or any hint of that, they should reach out immediately to lawyers. You're saying that the legal services organizations are also gearing up so that if you get notice that your landlord's going to sue you over that, they should also reach out and try and get some advice?
Absolutely. The legal aid organizations are all preparing to address this issue.
And I guess this is a question. I know that in general, when there's an actual trial of in small claims court, you're actually, neither side's allowed to have a lawyer, as I understand it in normal law. Does that apply even to this new expanded, or will people be able to bring lawyers to help them?
No, you won't be able to bring a lawyer, but also the landlord won't be able to bring a lawyer. So there will be more of an equal playing field. But it is important to get to legal aid or some attorney beforehand to help you prepare to present your case at the hearing.
Okay, so that's what people should keep in mind. If you get that, reach out right away. While they can't represent you in court, they can help you know what you need to file with the court and what you need to do to prepare and get you ready to present your case. Okay, great. Thank you for that. And thank you all. We're going to turn it over to Ed in a minute, but I think the critical takeaway lessons that I hear are number one, if you at all think you may be eligible for that state rent subsidy program, please go ahead and apply immediately. If you get any hint of an eviction action, you've heard some of the things you do to protect yourself, but also reach out to the legal services providers to get some help there. If your landlord, when the time comes, seeks to sue you for the portions of the rent that the state says you can't be evicted over, simply as a consumer debt obligation, again, reach out so you can get help in how to respond to that. And I know we received one question from someone who had a very specific question about what happens and when the COVID's over and people are allowed to, again, move people out for construction in their building and the like. And just want to let you know, we're gonna reach out to you by email and put you in contact with the folks at Legal Aid, and they'll talk to you about your specific situation. And so with that, I'm gonna ask Jen Kennedy, who is our SMRR professional and a member of the steering committee, if she could just display for the moment the contact information for all the folks that you've heard today. Okay, and so hopefully everybody can see that. Here's how you can reach out by phone to all of the folks. And we'll also, when we post this, we'll put on in front of that everybody's email, and maybe each of you could provide an email address if people want to reach out to you by email. Maybe you could just say it now since we don't have it written down here. Here's the phone number. We can leave that up, but could each of you say what the email address is if somebody wanted to reach out to you that way?
Sure. You can contact me at edis, eda.suh@smgov.net.
And at
Thank you, Eda.
LAFLA, our email, both of us have long email addresses, so I won't try to spell them, but they're our first initial and last name at lafla.org. So D McGranahan and R Ganschow at lafla.org.
Great, thank you, Romy.
And at Tzedek, it's first initial, last name. So H Kommel at betzedek.org.
Great, thank you, Hana.
And I'm at N Sultan, so NSULTAN at MHAS-LA.org.
Great. Well, I want to thank all of you for taking so much time to prepare for this, for sharing your time and expertise with everybody today, and for everything you do when you're not here with us. But we're not quite done yet. We do want to talk to everybody so that they know how you can reach out to SMRR and how SMRR can be of direct assistance to you. And so I'm going to turn it over to Ed Hunsaker. And Ed, if you could explain who you are and what you do.
Yeah, hello everyone. This has been a great webinar. A lot of extremely valuable information. My name is Ed. I am one of a few people in SMRR who answer a hotline phone number. And we've been doing this for many, many years, many more than I have. This hotline is for tenants to call with questions, and they can call with questions about anything. And you can call 24/7. And you'll leave a message, and we pick up the messages and then return the calls. So this is a very valuable service. Many people have been able to resolve their differences with landlords and other tenants, and also just their own personal angst about how to get through COVID and what to do and how to think about it. So I urge you to call. I'm going to tell you the phone number here in a minute or two. So if you get something to write it down with, I'll give you the phone number. I would say that when you do call, please speak. When you leave a message, please speak clearly. You don't have to leave your name, but it helps. But if you need a call back, you need to leave your phone number, and you need to leave it very clearly. Too many times people call in and they just verbally rattle off their phone number, and we cannot understand what it is. And we can spend 2 or 3 days trying to figure out what that phone number is. And by that time, the tenant's issue may have already escalated to a point beyond which we can even help. So when you do call, please speak clearly and leave your phone number very clearly. So there's our phone number right there for the hotline. And again, it's open 24/7. And just call, leave a message, and somebody will get back to you as soon as we can. I have one comment here. I was just going to mention this because the discussion leading up to this right here was I'm going to say this because this is a question that we're getting on the hotline a lot right now. What happens with a tenant who then where the landlord gets a judgment in small claims court against them for back rent, and then they cannot pay that judgment in some sort of timely manner? And the question is, how soon, when that happens, how soon after the judgment does the tenant have to pay that judgment before they can be evicted for not paying a judgment of back rent.
This is Denise. I'll just answer the question. You can't be evicted for the back rent because of a small claims action. You'll just have a judgment against you. It will be sealed if it's COVID related. The landlord can pursue the judgment and get it renewed after 10 years. If you're judgment proof, which in many instances is the case with our clients because they're on government benefits or just have low income, then the chances are that they're judgment or collection proof, we like to say, as opposed to judgment proof. So it's really important to know you're not going to be evicted for that rent. You will owe it, but you will not be evicted. And one thing, I don't know if it came up during the discussion, is that if your landlord refuses the 80/20 plan through the state, that the court will have the discretion to reduce the judgment to the landlord as sort of punishment for not accepting the 80/20 plan. So there is a chance that you should absolutely fight it in small claims court, because that, especially in that instance, because you might get your rent, the amount that you owe the landlord may be reduced. So I hope that answers the question.
Thank you.
Yeah,
Thank you.
great, Denise. Just before you drop off on that, Ned, and before you put in your final word. So I want to just make sure I understood what was just said there. So you can't be evicted for that debt. And maybe some people, there's nothing you can collect, but there is for other people, who have income and the like. It's possible that landlords could try and take some other kinds of actions to enforce that debt against you. Like if you earn enough money, trying to get a portion of your wages or go after your bank accounts or things like that. Am I right about that?
Yes, I mean, and you can try to file a claim of exemption.
Sure. I don't want to get into all the details about it. My point is I want people to understand that even though you can't be evicted for it, it really is important to try and minimize the chances that you're going to be obligated for that. So just to reinforce the message, as Denise said, the courts are going to have the authority that if you tried to get the state rental program, you qualified for it, and your landlord refused to take the 80% and then just give up on the other 20% so they can't sue you, the court could decide that, well, they could have had the 80%, so I'm not going to make you pay that. That's their own fault. Is that basically the idea, Denise?
Right. I mean, we don't know how that's going to play out, but the
Right,
law.
but it's at least possible that could happen, which is another reason why it's really important for anybody who's potentially eligible for the state rental assistance program to try and do it. And because of those other possible ways that your landlord can try and collect that, it is important that you reach out to Legal Aid and the other organizations, as Naomi said, to get advice about how to try and defend yourself in those kinds of lawsuits. So I just want to make sure that people understand that it's still important that you do everything possible to fight that and to, protect your rights as much as possible, not just think, oh, well, they can't evict me. I don't have to do anything if they try and come after me for that rent. So, okay.
The other point I'd like to make is that you should document very well that you asked your landlord to take the 80% and waive 20%, and because you need those records when you're in small claims court to be able to prove to the court. So make sure you document everything that you do through this whole process.
Okay, any final words on the hotline? I have a couple questions for you about it, but okay, so Ed, I just want to be clear. The SMRR hotline isn't providing legal advice to anybody, is that right?
Very good point. We do not, and we are barred from offering any kind of legal advice. What we do is offer advice of where to go to get legal advice. And you can go to the city, you can go to the Rent Control Board, you can go to LAFLA, legal aid foundations, and we really try to help the tenants navigate how to resolve their dispute. We cannot advocate for them in a legal way, but we can help them find out how to get it done.
Great. So it is an excellent way. You've seen today and heard today various ways to contact the folks that were kind enough to donate their time. But if you forget, if your problem is something different, then, you know, what we've talked about today, the SMRR hotline is a good way of getting somebody who can hear and may be able to direct you to, you know, what resources you ought to access, what kind of questions you ought to ask those resources in order to do it. And so with that, I want to thank everybody. I want to thank everybody who watched. I want to thank everybody who participated. We at SMRR hope that you found this helpful. As I said, please reach out to us, whether it's through the hotline or through our email, about your experiences with the state rent subsidy program or with anything else. We can only be as effective in advocating for renters as we know what the problems are. And thank you very much, everyone. And everybody stay safe and well, and hopefully we'll soon all be back together again in person. Take care, everybody.
Thank you.
Thanks.